An Estate Planning Guide. Chapter 1. Estate Planning 1. Estate Planning Introduction. Estate planning is making plans now for what will happen to your money, stuff, and assets when you die. If you don't have much, you can still make a will to give everything to one person or an entity like a church, animal shelter, etc. If you don't do this, the government comes in after you die, has a process called probate where they, the government, and lawyers usually get part of your money, if not all. Quite often, the probate process in court eats up at least part or all of the estate money in lawyer fees. The objective is to avoid probate for your heirs. Give away most of your stuff now. Put your house, car, and bank accounts into joint ownership so when you pass, ownership goes directly to the co-owner. You can buy a will book for under $20 from self-counsel.com or nalo.com. There are even free will forms online that you can print out if you have a printer. You can go to a library and ask a librarian to go on a computer to print you out some free will forms. You might have to pay $0.25 per page of printing or so. You should learn about estate planning simply because large amounts of money are consumed by estate taxes, fees, and other expenses when loved ones die. Many people work all their lives then end up barely spending a few hours learning how to preserve that wealth. If you have a reasonable amount of money, you should learn about estate planning on your own. Hire a competent accountant, an attorney, and a good tax man to get them all to run through a plan of what you should do with your money in the estate planning sense. These experts cost money, but they might have a tidbit of information that will save you much more money than it costs to hire them. The golden rule is to educate yourself now no matter how old you are and get it all in order such that your next of kin knows all about it when you pass on. Two things are certain, that the laws regarding death taxes and probate are always changing, which is why you should look them over every 5 years or so, and after you make your will, you should go over it every several years to revise it. Estate planning books are located at number 346.73 in the library. Nalo Press at nalo.com publishes a book called Plan Your Estate, which breaks down some of the state laws regarding estate/death and inheritance taxes and sells for about $20. Books about reverse mortgages are at number 332.722 or HG 2040.45 at the library. This book focuses on creating a will, joint ownership options, reverse mortgage, creating a trust, a conservatorship, probate in court, etc. Estate Planning 1. You should learn about estate planning simply because large amounts of money are consumed by estate taxes, fees, and other expenses when loved ones die. Many people work all their lives then end up barely spending a few hours learning how to preserve that wealth. If you have a reasonable amount of money, you should do some learning about estate planning on your own. Hire a competent accountant, an attorney, and a good tax man to get them all to run through a plan of what you should do with your money in the estate planning sense. These experts cost money, but they might have a tidbit of information that will save you much more money than it costs to hire them. The golden rule is to educate yourself now no matter how old you are and get it all in order such that your next of kin knows all about it when you pass on. Two things are certain, that the laws regarding death taxes and probate are always changing, which is why you should look them over every 5 years or so, and after you make your will, you should go over it every several years to revise it. Your estate is your accumulation of wealth over a lifetime. Many people go through life and never bother taking stock of what they're worth in material terms. Then when the inevitable happens, as in the case of accidental death or even old age, they leave a mess for their loved ones, or they simply plan poorly and the heirs end up paying out a lot of death taxes or inheritance taxes. No matter how you do it, it's a good idea to get something down on paper as to exactly what you're worth and what you want done in case of death or extreme disability. Probably the second biggest tragedy after death itself, which is a natural process anyway, is the fact that people don't prepare and tell their heirs what's going on. In a nutshell, get all your paperwork together. Make up a will and trusts if applicable. Learn about estate planning, especially about taxes if your estate is valued at over the current estate tax exemption value. Sit down and tell your kids about what to do after you die. Get medical and health insurance. If you have dependents like a wife and children, you should sit down and write out a list of all your assets so they will know exactly where to look should you die. Estate planning books are located at number 346.73 in the library. Nalo Press at nalo.com publishes a book called Plan Your Estate, which breaks down some of the state laws regarding estate/death and inheritance taxes and sells for about $20. Do a lot of the learning and the paperwork yourself. Most estates aren't very complicated and just require the filling out of rote forms, hence, you may not even need a lawyer. A paralegal might do. If you need a lawyer, your family lawyer might do, but if you have an extensive estate, consider getting a referral for a specialist estate lawyer. They could save you a lot of money by finding loopholes to avoid probate and estate taxes. One way to get a referral is to ask at the trust department of your bank because they deal with lawyers all the time. If you go to your local bar association, they will just give you a list of names, so you should interview several before you decide to hire one. Lawyers are notorious for prolonging probate so that they can continually collect fees. Marilyn Monroe's estate took 18 years to settle, and when it was all over, lawyers took about $1 million of her $1.2 million estate. Anybody can call themselves an estate planner and go into business without any formal education or licensing, so don't trust self-proclaimed estate planners unless you know them well. You can do most of your estate planning yourself if you know what you're doing, but most people generally get two people to prepare their estates, a lawyer and an accountant, and some also get a financial advisor. If you have an ethical advisor committed to serving their client, they will save you money, but if they're just rubber stamping all their many clients through, they will just do the minimal paperwork and not look for tax breaks specific to you. Make a will, sign things over in joint tenancy so when you die, ownership goes to the living spouse, and give your close relatives power of attorney over your assets, like accounts, to avoid hassles by probate at death. Do all these things properly so they're legal. If you make the will yourself and skip one thing, it could be rendered null and void, so follow the rules. Educate yourself about Social Security, doubly so if you're a veteran. Do some research on your own before you buy insurance because the costs can get quite high. Decide on how much you need and how much you can afford and strike a middle balance in there somewhere. Check with the company you work for to find out if they have life insurance or coverage plans in the event of your death. Group insurance plans are almost always cheaper than going out on your own. The first decision you have to make is whether you're going to play according to Uncle Sam's rules or not. Estate planning is so complex because of the government and its taxes. Use your head, quietly play by your own rules, know what you're doing, and you don't have to give the government any of your money in estate or inheritance taxes if you liquidate before you die and quietly hand it off to heirs. As you get older, keep the current estate tax exemption value in mind. You don't pay federal estate taxes on the value of your estate if it's below the current estate tax exemption value. Anything above that and you pay taxes up to 55%. Note that this value will increase as time goes on. Try to give away your assets before death. If you're married and on paper, one spouse owns more than the current estate tax exemption value and the other not, try to balance the ownership out to as close to the current estate tax exemption value each as possible to avoid estate taxes upon death. A popular scheme is to sprinkle your assets into several trusts to maximize tax-free benefits for each of your heirs. In my opinion, the easiest way to deal with your assets if you are wealthy and old is to put most of them in offshore accounts out of the United States and include a power of attorney form with them giving someone else ownership when you die. This is if you want to avoid estate taxes. Your best bet is to provide for your wife with a trust upon your death and give away the rest of your wealth quietly while you're alive with the least amount of paperwork as possible. In order to keep it legal, give away chunks valued at less than $11,000 per person per year. If you go over this, you're supposed to file Tax Form 709, the gift tax return. See below. You're allowed to leave as much you want to your spouse tax-free, but that just leaves the pressure on her to get the estate below the current tax-exempt value before she dies in order to avoid paying estate taxes. In the event that you will probably have to pay estate taxes, work it out with your bookkeeper so that you leave X amount to your favorite charity, which will deprive the government from getting the money. To keep your assets until death, then pass them off right away to your heirs. Put a bunch of stuff in a safe deposit box with instructions to the bank to turn all rights over immediately upon death. Or better still, keep your assets in a private corporation safety deposit box as opposed to a bank safety deposit box paid with cash to keep the IRS snoops away. The IRA is taxed when you die. Life insurance benefits aren't. Take your money out of the IRA, buy some life insurance and give the rest away to your relatives. The estate tax exemption is no good if you leave everything you own to your wife. She dies with possession of your $2 million, which is now taxed for about $900,000. Use your estate tax exemption to give the money to your kids. That way your wife won't end up with it, with the money being taxed on her death. Estate planning 2. When planning your estate, there are a number of snags you could get into regarding disbursement of your assets either before or after death. Probably one of the biggest is trying to give an equitable amount to all your children. Your assets are not like straight money, so there will probably be bickering and jealousy if you leave one child the house, the other the car, the other some money, etc. A good way is to leave instructions like bequeathing a certain percentage of the proceeds from your estate to your heirs. For example, you could instruct that the house be sold and each of your 4 children get 25% of the payoff. In short, try to divvy up the stuff equally among all your deserving heirs. If you don't want to leave too much of a lump sum to them, you can always draft up a living trust or a conditional will where you instruct a trustee like a lawyer or a trusted friend to give those heirs only a certain amount of money every month or every year. If you have minors or grandchildren, leave money for them, most likely in a living trust where you can make specific instructions on how to disperse it to them. Do the same for handicapped relatives. Take care of all custody arrangements like who will care for your children and handicapped relatives in the event of your death. Consider all children from all marriages and all your wives when planning to resolve your estate. In addition to giving away specific things, you should name a residuary beneficiary with an instruction like everything else to, which gives that person all the rest of your minor things like clothes, tools, etc. If you have got a sneaky wife, don't leave all the money to her and expect her to divvy it up among your children fairly. She might decide to blow it all, so leave money to each individual specifically. Don't forget adopted and out-of-wedlock children. Whatever you decide to do, don't just write it up and then lock it away. Tell your wife, heirs, friends, and lawyers specifically about your intentions with them. Make your funeral and burial plans in advance. If your estate is tied up in a business or property, try to convert some into cash so your heirs will have money to settle your affairs, including the dreaded estate taxes if you have to pay them. A common problem for heirs who inherit businesses is that they're business rich and cash poor. Then when the IRS does the assessment on the business and they owe hefty estate taxes, they have no money to pay, so they have to either sell the business or declare bankruptcy. If you're in a common law relationship, there are laws which give your common law spouse a right to your estate even if you specify otherwise in a will or trust. Whether you die with or without a will, most states have laws where the wife and children automatically receive a certain percentage of your estate, so if you have been separated but didn't get divorced, your long-lost wife could come back to claim a piece of your estate. If you specifically want to disinherit a child or spouse, don't just leave them out of the will. State that you're disinheriting them. If you're single, draw up a will with specific intentions just like married people do, otherwise the state will end up getting the proceeds from your estate. You may consider forgiving debts that are owed to you. There are clauses called survivorship periods where you essentially draw up 2 wills, one that goes into effect if one of your major heirs dies within a short period like 1 to 5 years after your death. There are clauses called simultaneous death clauses where you leave instructions in the event you and your spouse die at the same time. If you're married to a non-US citizen, he or she doesn't get the estate tax exemption in what you leave them when you die, but you're allowed to give them $100,000 each year as a tax-free gift. Buy life insurance to cover death taxes. You can't will property to minors because they aren't allowed to own property. If you own property and investments outside the country, Try to resolve it before you die because it will take time and cost high legal fees to take care of it after death unless you have power of attorney forms already signed giving someone else ownership when you die and this other person presents a death certificate to the relevant authorities. If you own holdings in 2 or more states, you will have to file probate in each of those states, so try to get rid of what you own in everything but one state. Make sure you leave enough liquid money in your estate so that your heirs can pay out expenses without having to sell the house at an estate sale. If your children are young, you can give them gifts under the Uniform Gift to Minors Act with a custodian watching over it until they reach maturity. If you're over 55, you get a one-time $125,000, or whatever the current rate is, exclusion on the gain from the sale of your home using IRS Form 2119. You're taxed on 50% of Social Security income. If you're an unmarried, older couple, consider getting married to take advantage of the transfer of assets for your estate. A popular technique is to sell your home to your children, continue living in it and draw up a bona fide rental agreement with a paper trail of rental payment to keep the IRS hounds off when your estate is calculated later on. If you want to legally get rid of a lot of money, make them charge you a high rental fee. Buy a home with children or grandchildren, or buy a home and rent to children with an option to buy. Check with a lawyer about putting your life insurance policy into a trust and about what you can do to minimize state death taxes. Move to a state with lower death taxes. Private annuities are a situation where you give your children your home, they pay you a monthly fee for life and you pay no estate taxes. If you have an elderly relative who needs financial assistance, open a custodial account, not a joint account, which could make you liable for their debts at death. There's a generation skipping tax where you're taxed on what you give your grandchildren, but there is an exemption of around $1 million. If you give your house to your child, he or she must have the title and you must pay rent with a lease agreement in order for the IRS not to pull it back into your estate. Another solution is the grid trust discussed elsewhere. If you have a valuable art collection, consider starting a corporation, donating it to it, then your heirs can sell it and keep the money for themselves. Finally, do research on your own as to how to legally structure your estate, but once you have it all down on paper, your best bet is to find a lawyer specializing in estate law to look over and manage your plans to make sure it's all legally sound, and if you find a good one, he will know the loopholes to save you money where it counts. Estate Planning 3. Many people's estates get sued after they die. They have lawsuits levied against them by creditors. Beyond trying to get your estate below the tax exclusion rate, approximately $1.5 million for an individual, $3 million for a couple's estate, you want to take care of your business such that your assets are free and clear of all debts when you pass, such that your heirs get it free of lawsuits and other creditor claims. The most common estate planning methods people use are: give stuff away, sign it over to a relative or sell it to a relative for a song while they live. Make up a will which goes through probate. Make up a living trust which avoids probate. Buy a big life insurance policy which immediately pays off to the beneficiaries. Get all big assets in either joint ownership or as tenancy by the entirety. Most states allow jointly owned property to pass to the surviving joint owner free of all creditor actions against the deceased joint owner. Buy annuities, the balance of which pass to beneficiaries at death. Overall, the best way to avoid creditors and lawsuit judgments beyond putting the money into foreign accounts, hiding your cash or putting it in other people's names is to make it hard for creditors to get at it by muddling the paper trail. There are several ways to do this. Instead of putting one big sum of money in one place, create 5 or more LLCs, trusts and foreign trusts to spread it out. Just don't forget where your money is. In order to avoid fraudulent transfer charges, don't make big moves with your assets. Transfer a little bit at a time. It looks like you're just doing an orderly personal retirement savings plan as opposed to trying to fraudulently transfer something. At the very least, make up a will, then update it every 3 years or so. Make up a durable power of attorney to take care of both your medical needs and financial/legal affairs should you become mentally incapacitated. Make up a living will to deal with the issue of prolonging your life artificially should it ever come to pass. The more money you have, the greater your need for a professional estate planner, either a lawyer or a consultant. The few bucks you spend on them could save you lots of money. Chapter 2. Estate Planning 2. Federal Unified Tax Credit. Estates have to file the Federal Estate Tax Form 706 upon death. Get the form now and fill it out to have ready when you die. Many people incorrectly underestimate the value of their estates, so get it down on paper and be accurate. The estate tax exemption means that if your estate is valued at under a certain dollar level, you're exempt from estate taxes. If your estate is valued at under the current exemption value, your estate pays no federal estate taxes. If over the current exemption value, the federal government takes a piece of it starting at 37% going up to 55%. A big mistake a lot of people make is that when the husband dies, he leaves almost everything to the wife, and when she dies, she now only has half the estate exemption they had as a couple. Hence, if they are wealthy, they should try to get their estate down to below the current exemption value now in order not to pay estate taxes by giving the money away to their children, grandchildren, siblings, etc. If you as a couple have assets worth more than the current exempt estate tax value, first try to get the estate down to below that value while you're alive by giving it away to your heirs or spending it, then disperse your estate into two estates valued below the current exemption value. When one dies, if the other gets that value, their estate will be taxed upon their death, so give it away immediately to heirs instead of passing it on to the wife where it will be taxed later. The alternative to all this is, of course, to spend your money while you're alive to get below the estate tax rate. If you own a business which is valued at over the current estate tax exemption value, your best bet is to either incorporate, go public, or sell it before you die and quietly give cash disbursements to your relatives to avoid the tax man. Barring that, change ownership to your heirs while you're alive to work out all the kinks and avoid paying estate taxes upon death. Look into incorporation for the business. Go to irs.gov or get the following free IRS booklets for the latest information. 448 Federal Estate and Gift Taxes. 904 Interrelated Computations for Estate and Gift Taxes. 950 Who must file gift or estate taxes. Joint tenancy with right of survivorship / JTROS. Joint tenancy is a form of property ownership by two or more people where the death of one owner causes the transfer of that individual's share to go directly to the remaining owner. A will has no power to change the joint tenant's right of survivorship. Joint tenancy is the simplest way to resolve someone's estate at death. Simply put everything you own together with someone else, like your spouse or children, things like your house, bank accounts, and investments. Put their name on it too as part owners along with you. When you die, they get it all. The following states have restrictive rules about joint tenancy: Alaska, North Carolina, Pennsylvania, Tennessee, and Texas. In joint tenancy cases, the husband's assets will go to the wife, then when she dies, the federal exemption that the couple had before is now cut in half because it's just her. Hence, any assets over the current exemption value are taxable by the federal death tax. Joint ownership can be risky. For instance, if you put your house in your child's name jointly with you and he gets into deep debt, goes bankrupt, or gets in an accident and has a lawsuit filed against him, they can come and take the house away from you. There are federal estate taxes and state inheritance taxes on interests received by survivorship in joint tenancy with right of survivorship. avoid-probate.com/b-joint-tenancy.htm. justinswer.com/questions/1202l-own-home-deeded-joint-tenancy-w. Tenancy by the entirety. A married couple can enter a tenancy by the entirety, which means that neither one can transfer the real estate property while you're both alive. You have to both willingly do it together. About 30 states have this procedure. Gifting, gifts and taxes. 1. The annual gift tax exclusion allows you to give $12,000 annually per person, tax-free, with the provision that the gift is immediately available to the recipient. You and your spouse together can give $24,000 per person, to each of your children and anyone else, per year without income tax consequences. If you give away more than $12,000 to a person, you have to file a gift tax return. Over your lifetime, you're allowed to give up to $1 million of your estate away without paying a tax on it. Anytime you give someone over $12,000 in a year and fill out a gift tax form, this amount over $12,000 is added to the total until you get over $1 million, then it's taxed. There are two types of gift taxes. Federal IRS. State. The advantages of gifting is twofold. You take the money from your taxable income and give it to someone in a lower tax category. You're reducing your estate. Your final goal is to bring your estate down to the current exclusion level, approximately $2 million for a single, $4 million for a couple. The IRS has some provision where you can transfer a big asset in installments, equaling $12,000 per person per year without tax consequences. You can give bypass generation gifts to your grandchildren which have tax consequences, or you can form a generation skipping trust. If you have creditors, give away your most vulnerable assets before you give away your safe ones. You can transfer property to a minor child through a children's or minor's trust. A minor's trust is safe from the grantor's creditors if the trust is irrevocable, which means it can't be changed and the asset transfers are not deemed fraudulent transfers. If the child beneficiary has creditors, they cannot be seized until they are actually distributed to him or her. You can gift assets to a minor child under the Uniform Transfers to Minors Act. Technically, you're allowed to give away $12,000, or whatever the current rate is, tax-free as gifts per year per person, but you can slide a lot of your estate around that and give it away quietly. Gifts to spouses are not taxable. Legally, you and your wife can each give each of your children, their spouses, and your grandchildren together $24,000 a year tax-free. You give each $12,000 and your wife gives each of them $12,000. Of course, you can just as easily withdraw cash from your bank account and quietly pass it on to your children. You're supposed to file Tax Form 709, the gift tax return. Your best bet as you get older is simply to start liquidating your accounts and give the money to your heirs, but keep some around in case of unforeseen events like illness or an accident. If you die less than 3 years after you give away large gifts, they may be added to the value of your estate. If you're quite wealthy, get it all as liquid as possible and try to give it away while you live to keep it as simple as possible. If the IRS hassles you about making large withdrawals from your bank account with nothing to show for it when, in fact, you gave it to your children, you just say you spent it having a good time. For more devious techniques, refer to chapter on protecting your money. You can give each of your grandchildren $12,000 a year tax-free too. Under the Uniform Gifts to Minors Act and the Uniform Transfers to Minors Act, you can fill out forms enabling a banker or financial planner to keep the money until the child turns 18, 21, or 25, whichever you choose. If you name yourself the custodian and die, the money will be considered part of your estate, so it's best to name a younger friend or relative as the custodian to avoid estate taxes on it in probate. Go to irs.gov or get the following free IRS booklets for the latest information. 448 Federal Estate and Gift Taxes. 904 Interrelated Computations for Estate and Gift Taxes. 950 Who must file gift or estate taxes. Like I've already said several times in this book, if you have a lot of assets, liquidate and quietly start giving your heirs cash so you don't leave a paper trail. If the IRS asks you where the money is for the house you just sold or the stocks you just cashed in a few months ago, tell them you're enjoying your life traveling around, hiring girls for dances and gambling, then smile and keep your mouth shut. Gifting, gifts and taxes too. You can't give your house away without paying lots of tax on it, so do the sales leaseback thing with one of your children as discussed elsewhere, and do it while you're at young old age so the IRS can't come in and say the deal was too close to your death and disallow it, within 3 years. If there's more than 3 years between the time of the sale of your house to your kid and the time of your death, they can't nullify the deal and put the house in as part of his estate. I'm not a great lover of the government. I think we're taxed all to death, so if I were an American with a reasonable estate, I'd give most of it away under the table, so to speak, to my heirs while alive without declaring it a gift on my income taxes. I'd give them most of my material things like tools, TVs, etc., sell some things like my RV and boat and give them the cash quietly. Then I'd liquidate my investments, convert them to cash and hand it over to my heirs so there's no paper trail saying I transferred my stocks to my kids. If any government official asked me what I did with the money I liquidated, I'd tell them I'm going to die broke, as the title of a pop culture money book says, that I have been going around having a good old time gambling it away and watching strippers. That's my view. Do what you want with it. Remember, whatever you die with that's in your estate over the current federal estate exemption value, will be taxed, so consciously bring your estate down to under that amount by liquidating and either taking the money to a Caribbean island or Switzerland or giving it to your heirs now. If you put things in joint ownership, with right of survivorship with your wife, they're automatically passed on to her when you die, but when she dies they become part of her estate, which will be taxed if she owns more than the current estate exemption values. So a better way is to put things in joint ownership with your kids, but structure them such that they can't be considered gifts, which means you say the kid contributed to the purchase of them. Your best bet is not to even bother putting your name on the deed of whatever the product is, house, car or anything. Buy a car, put it in your son's name, but for all intents and purposes, it's yours until you die. Do the same with a house. If the IRS want to know where the kid got the money to buy the house outright, he tells them he's been saving all his life and had some good winnings in Vegas recently. Beware that all this could backfire if your kid dies before you or some tax snoop finds out, but chances are he doesn't have much of an estate, so there won't be a lot of death taxes involved. I'm just flying by the seat of my pants with ideas here, some obviously illegal, so check with someone else who might know about this stuff before you go through with it. Chapter 3. Estate Planning 3. Death Benefit Claims. When somebody dies, there will probably be death benefits available to his next of kin, like life insurance, mortgage/credit insurance, employee pension and other benefits, earned income due like wages owed, vacation pay, sick pay, etc. Wrongful death benefits, Social Security benefits, veterans benefits. The big thing about these benefits is that they don't automatically come to you, the heirs of the estate. You have to go out, file claims and make them happen. Disinheriting someone. If you wish to disinherit a spouse, better check with a lawyer about laws, because some states have laws preventing this. Spouses generally can't disinherit one another unless there's been a serious breach of the marriage contract like abandonment or violence. In some states, if the husband leaves the wife a little bit of his estate, she can reject the will and take the mandatory minimum, which is 1/3 of his property. Even if wives aren't given the house, they're often entitled to it until death, then it goes to who the husband willed it to. The following states have courtesy rights which protects a husband's interest in property so that the wife can't disinherit him: Delaware, D.C., Hawaii, Kentucky, Massachusetts, Ohio, Rhode Island, Tennessee, Vermont, Virginia, West Virginia, and Wisconsin. The following states have dower rights which protect the wife from being disinherited by the husband, entitling her to at least 1/3 of his property: Alabama, Delaware, Florida, Hawaii, Kentucky, Massachusetts, Michigan, Montana, New Jersey, Ohio, Rhode Island, South Carolina, Tennessee, Vermont, Virginia, West Virginia, and Wisconsin. In order to disinherit someone other than spouses like your kids, it must be stated specifically in the will with reasons so that they don't challenge it thinking it was an oversight on your part if they don't see their names listed. Or just spite them by leaving them $20 and your old shoes. Inheriting money info. Most people don't inherit much because it's often dispersed to several people, plus the fact that most people don't have that much left when they die, what with the costs of medical care, legal help, the funeral, etc. If you inherit a significant amount of money like over $50,000, chances are you will spend some of it on frivolous things that could be used more practically in another situation as you get older. So the lesson is, don't do something stupid with it right away thinking you have to spend it rather than leave it sitting somewhere collecting interest. Sure, buy yourself something nice, but my advice is to pay off all your debts including your mortgage and put the rest away into savings until you really need it. Learn about investing money. Get professional advice about minimizing taxes. Find out what taxes, if any, an inheritor must pay in your area, usually called inheritance taxes, distinct from estate or death taxes which come from the decedent's estate, while inheritance taxes come from the people getting the money. Get a good tax man who knows the loopholes so you only pay minimal taxes on either side, either the estate taxes or inheritance taxes, either through exclusions or deductions. Someone will probably have to make out a terminal tax form for the decedent. Major studies done on people who inherit large amounts of money have shown that if they don't use their money to become investors or business owners, they generally get depressed and aimless, kinda like Daisy in F. Scott Fitzgerald's The Great Gatsby, who after a frivolous, aimless afternoon mused, "Now, what do we do with ourselves for the next 30 years? It's the same with people who win lotteries. Unless they're fairly grounded and have some kind of purpose in life, like meaningful work, many self-destruct and go to pieces, seemingly guilty about having all that easy money and subconsciously trying to rid themselves of it by gambling it away, giving it away, partying it away, etc. There has been more than one case of some suddenly rich guy buying a bunch of things, starting work on a big dream house only to go bankrupt before the house ever gets completed. You need self-discipline and some kind of inspired purpose in life if you want to deal with a sudden windfall in a healthy way. There's a lot of self-contempt among inheritors, like they didn't earn it themselves, which is a cardinal mark of shame in our achievement-oriented capitalist world. Inheritances of large amounts of money also break families up because everybody is jealous of whoever gets the most. Many inheritors feel bored, inadequate and guilty. Some get arrogant just because they have money, which is a false sense of how powerful they really are, not powerful at all because they didn't do it on their own. If your parents are getting old, talk to them about your inheritance. If you're getting old, talk to your kids about your will. Many parents are unwilling to talk to their children about their deaths at some point in time and the financial repercussions after, so either give them this page with these lines underlined or ask them to write things out for you about what they want later. Funeral details, both religious-wise and money-wise. Death benefit of pension plan, if applicable. Social function to help grieving people comfort each other, like a get-together after the funeral. Newspaper announcement. Legal affairs, have a will, trust, and other legal documents transferring ownership at death, joint tenancy of home, life insurance benefits, ready and out in the open. Make several copies and give them to all concerned people. Pick 1 or 2 executors to manage everything. Deal with debts. Disbursement of assets, often at a reading of the will after the funeral. Take all the smaller trivial things in your home and give them away now, or promise them to certain people and put it in writing, things like your lawnmower, gun collection, wardrobe, etc. Relax, simplify your life and get ready for the inevitable in peace. Everybody will die, so be mature about it and do what it takes to help your spouse, children, and other relatives be ready for it. With a family business or the case of several marriages with several kids from different marriages plus grandchildren and stepchildren, it could get complicated, so spell everything out in as much detail as possible, and if you want to be equal about it, appoint a man and woman team as executor of your will in order to avoid the traditional male bias and takeover of the property that's so common. To die intestate means to die without a will, which means that the government appoints its own executor to disperse the assets through the tedious process of probate, which is way more tedious and longer than if done with a will. So for the sake of the few bucks it costs, get a will made if your assets are worth more than $10,000. Find out what the laws are in your province/state. When women get an inheritance, they often give some of it to the husband, but you should keep most of it for yourself in a separate account and not even tell him about it. A common problem for heirs who inherit businesses is that they're business rich and cash poor. Then when the IRS does the assessment on the business and they owe hefty estate taxes, they have no money to pay, so they have to either sell the business or declare bankruptcy. You may choose not to accept your inheritance, in which case it's called disclaiming your interest. You must notify the executor, as there are time limits as to how long you have to do this. In order to avoid people contesting the will like a jilted spouse, put a provision into the will that anyone who contests it loses everything. To keep it simple, liquefy your inheritance into straight cash as much as possible. If you don't particularly want the house, the car, or the business you inherited, sell it all for straight simple cash. I say you need a good tax man to help you with loopholes, but beyond that, learn about investing and invest the money on your own without hiring an investment advisor. Even though estate planning books are generally in the legal section at the library, number 346.71-73, Family Law, or K.5974 and KF750, you might find a book or two on inheritance at number 332.024 or HG179. inheritance-project.com. Disclaiming an inheritance when you owe money. In the event that you owe a lot of money or have a lawsuit judgment against you and expect an inheritance soon because your aging parents are getting quite old, you can circumvent your creditors by disclaiming your inheritance and have it pass immediately to your children who are your parents' grandchildren or anyone else you might deem worthy, like a spouse or a sibling. Your disclaimer is a written document where you state that you don't want the inheritance and want it to go to whoever you name. You must not have already accepted any part of the property or any benefits of ownership in the will. Submit this document to the will trustee, the person who will be managing the will, probably your father's lawyer. An alternative way is to ask your father or whoever it is to change the will to direct the money elsewhere, since your creditors will just take the money if you inherit it. Your father can sign the money over to someone else without creditors, with the understanding that they will pass that money on to you once they get it. There are other ways to avoid creditors through an inheritance too. Have your father set up an offshore trust, an LLC, a domestic testamentary trust, or some other financial entity which is immune to personal liability by the owners, with you as part owner, such that when he passes, you take ownership of the asset which, for all legal intents and purposes, is owned by the trust, the LP, or the LLC, so that your creditors can't touch it. Life estate/sale leaseback. A life estate or sale leaseback is most commonly used among family and friends in order to reduce the bulk of your estate, your house, so it's not involved in probate nor death taxes. If your estate is in a taxable range, above the current exemption value, your best bet is to sell your house to your kids. You can't give it away to them without paying a hefty gift tax, so sell it to them. Draw up the papers and sell them the house. Pay them rent which they can use to pay you on the private mortgage agreement you make with them. Do this now because the IRS sometimes disallows such agreements if done within 3 years of death. This is one way to save the house and give your children tax benefits by claiming it as an investment rental property, allowing them to deduct the interest, taxes, insurance, maintenance, and depreciation on the property. In order to qualify, the sale must be at fair market value. Another way is to put the home in a trust, which is somewhat more complicated. So, to review, you simply sell or sign over your house to your children or a good friend and live in it either rent-free or pay them rent while they, supposedly, pay you a monthly private mortgage agreed to by the two of you until you die, then it's theirs. In some courts, if you do this within 3 years of your death, the court might assess it as part of your estate, so do it while you're still young and have at least 3 years of living left. The US has a certain limit on giving gifts without being taxed, currently about $11,000, so it's best to say in the contract, even if you don't actually collect the money, that they paid a reasonable amount for the house, or on paper, create a private mortgage between you and them such that they're supposed to pay you $700 a month, but if it's your kids, you probably don't expect to collect. Just keep it a legal sale so Uncle Sam doesn't classify it as a gift that exceeded the limit and tax the kids on it as part of their income. If you make a deal with a friend who's not that close to you, charge him a reduced fee for the house, which gives you a private reverse mortgage. You get some cash up front and he gets a good deal on the house when you pass on, but pick a friend who's considerably younger than you because you could outlive him otherwise. Don't do the stupid thing and leave your kids your house with no money because estate taxes are due 9 months after death, and if you don't have cash, you have to sell the house to pay the estate tax. Life insurance and estate planning. When an individual dies and leaves a sizable estate behind, it could be tied up in a business, home, boat, cars, etc. such that the estate is not liquid but there are taxes and bills to be paid on it, so some people who need quick estate liquidity for their families after they die in order to pay off the bills and not lose these substantial assets get high life insurance policies to cover this need for cash at death to pay bills like taxes. Some people take out high life insurance policies, then when they die, the payoff goes to their relatives tax-free without probate, who can then use it to pay off the high death taxes and other bills, so their relatives can then keep the family business or the house if there's still a mortgage on it. Many families that look good on paper are cash poor and often have to sell off the business or the house to pay the death tax. The death tax is a sore point for many farmers and middle-class business types who actively lobby to have it repealed. Corporations also use life insurance on their majority owners to protect themselves when they die. Talk to an insurance professional, lawyer, accountant and a financial services expert familiar with this concept in order to get more insight about it. This topic is beyond my interest level in money matters. It's too dry and technical. Although this is an obscure concept, you might find a book or two on the subject at number 332.0240 or HG9010 at the library. Leave money to pets/pet trusts. Pets are considered property, so if you leave your pet money for him or her to be taken care of for life in a will, it will just be nullified in probate court. Traditionally, pets were not allowed to be the beneficiaries of trusts, but the situation is now changed. The way you leave money to a pet in most places is to set up a pet trust with either the pet trustee as the guardian or someone else as the guardian while the pet trustee manages the money. The trust ends when the pet dies and the money is given to a secondary beneficiary. The simplest way is to leave money for a person you trust who will take care of the pet after you pass. fergusonskipper.com/pettrusts.hdm. Florida Estate Planning Lawyerblog.com. Can your dog inherit your estate? amco-independence.com/reference/kin-pet-inherit-money-under-a-will. gunterdog.com. ichmo.com/the-lifestyles-of-super-rich-pet- beneficiaries 2590. blogs.trb.com/features/lifestyles/pets/blog/2008/1/rich_little_pets_inherit.html. living.1india.in/home-hifan-hifan-garden/pet-care/2008/pooches-inherit-wealth-2091008.html. home.comcast.net/tilde-elacro600/pettrust.html. Chapter 4. Estate Planning Resources. Estate Planning Websites. Try number 346.71-73, Family Law, or KE 5974 and KF 750 at the Library for books on wills and estate planning. 360financialLiteracy.org. aarp.org/money/financial_planning. actc.org, American College of Trust and Estate Counsel. aeaweb.org. allaw.com. avoid-probate.com. gottrouble.com/legal/estate_planning. castleestateplanning.com. castlelaw.com. chicagoestatelawyers.com. diassetprotection.com. dieestateplanning.com. eldercare.gov. elderlawanswers.com. estate.findlaw.com/estate-planning. estate-legacy-vaults.com. estateplanning.cc. estateplanning.com. estateplanningschicago.com. estateplanningsconcepts.com. estateplanninglawfirms.com. estateplanningslinks.com. estateplanningservices.com. ethicalwill.com.